All rise.
The Kosovo Specialist Chambers is now in session.
Please be seated.
Good morning, everyone, in and outside the courtroom. Madam Court Officer, can you please call the case?
Good morning, Your Honor. This is case KSC BC 2020-04, the Specialist Prosecutor versus Pjetër Shala.
Thank you, Madam Court Officer. Now I would kindly ask the parties to introduce themselves, starting with the Specialist Prosecutor's Office. Mr. Prosecutor, or Madam Prosecutor, I don't know, who will lead today.
Thank you, Your Honor, and good morning to all present. Appearing today for the Specialist Prosecutor are Vega Yodice, Associate Prosecutor, Angel Langenberg, Case Manager, and I am Sean O'Dowd, Prosecutor.
Thank you, Mr. Prosecutor. Now let me turn to the defense. Mr. Gillissen, please. Microphone, please, Mr. Gillissen.
My mask and I forgot the microphone. So, good morning, Your Honor. Mr. President, I'm proud to introduce to you the member of the defense team of Mr. Shala. First, Mrs. Leto Keriolu, lawyer at the bars of Cyprus and the bar of England and Wales. Second, Ms. Tina Kuresek, lawyer who joined us from the European Court of Human Rights. Third, Ms. Zeneta Petrovica, who recently joined us as an intern. Now, Mr. President, you are familiar with Mehdi Awini, my co-counsel from the Bar of Tunis, and myself, Mr. Jean-Louis Gillissen, Specialist Counsel of Mr. Shala, from the Bar of Liège. And as you can see, Your Honor, compared to the first conference, we are happy to report that the gender balance has been reestablished, in fact, reversed. So, Mr. Shala is here with us via the video link from the detention center of Scheveningen. Thank you very much.
Thank you very much, Mr. Gillissen, and congratulations for the gender balance. I also note that the gender balance is also on the other side, so I congratulate all the team members. And I even see that the gender balance is also on the front row. So the only one who is not gender balanced here is me on the bench, but it's a bit difficult because I'm alone today. Let me now turn to the registrar, Madam Registrar.
Good morning, Your Honour. Fidel Madonlan, Registrar, and joining me today is the Deputy Registrar, Stefan Wolfhart. Thank you.
Thank you, Madam Registrar. And I remind all the parties and participants, as usual, to speak slowly and to wait several seconds before responding, so our interpreters have the time to translate everything into Albanian and Serbian. On 7 June, I scheduled the second status conference in this case. My goal today is to review the status of the case and to organize exchanges between the parties to ensure an expeditious preparation for trial. In particular, I wish to discuss disclosure of evidentiary material, the status of the specialist prosecutor's investigations, the date of the SPO pretrial brief and other related materials, the position of the defense regarding the status of its investigations, its intention to give notice of an alibi or grounds for excluding responsibility, and its intention to make requests concerning unique investigative opportunities. I would also like to discuss about the timeline for any preliminary motions at the end of this status conference, and I intend to issue an oral order on that matter. And finally, any other issues the party wish to raise. I thank the SPO and the defense for their written submissions ahead of the status conference. And as usual, I will invite the parties to present their views in a concise fashion about each item in the agenda that I will address individually. I remind also everybody in the courtroom to give prior notice should any submission require the disclosure of confidential information, so we can go into closed or private session. Let me start with the disclosure process. The SPO indicated in its written submissions that it completed its Rule 1021A disclosure on 19 May 2021. However, I note that the SPO indicates that it subsequently disclosed an unredacted version of an item. I thank the SPO in advance to indicate in its oral submissions when this occurred. I further note that 2 disclosure packages numbered 8 and 9 have been disclosed on 11 June 2021. I would like the SPO to indicate whether these packages contain Rule 1021A material as well, as mentioned by the defense in its written submissions, in which case we shall consider that the SPO only completed the disclosure of its Rule 1021A material on 11 June. And of course, this has an impact on the deadline for the defense to file any preliminary motions. The SPO also indicated that it is in the process of reviewing Rule 1021B materials for disclosure and redactions. As a result of this ongoing review, the SPO submitted its second protective measure request on 11 June, which is pending before me. The SPO indicated that the first batch of Rule 1021B material not requiring protective measures will be disclosed to the defense immediately. I invite the SPO to indicate if this has been done, partially or totally, with batch 10 disclosed on Friday, and if not, when it intends to disclose this material. The SPO also indicated that it's continuing to review Rule 103 material that is within its custody, control, or actual knowledge, and following application of any required redactions, it shall immediately disclose any such material on a rolling basis. Could the SPO indicate whether such material has already been identified and whether it has an estimated timeline for such disclosure to be completed? And finally, the SPO mentioned that it is continuing to engage with providers to actively seek Rule 107 clearances in respect of a limited amount of protected materials of potential relevance to this case. I invite the SPO to give further information about the number of evidentiary materials it concerns, the number of providers consulted, and any indication on a timeline for these clearances. And more generally, I would like to hear from the prosecutor on whether there have been any difficulties in the ongoing disclosure process or if they face any challenges with the current disclosure calendar. A lot of questions. I hope you will remember all of them. Mr. Prosecutor, the floor is yours. And if not, I will remind you the one that are not answered. Don't worry.
Thank you, Your Honor. We're grateful for that. Your Honor, disclosure is proceeding on schedule. To date, the SPO has fully complied with all of its deadlines, and the SPO has not experienced any difficulties related to the disclosure of evidentiary material. The SPO believes it remains on schedule to meet the disclosure deadline set forth in the framework decision. We note that we have timely produced the indictment, the detailed outline, Rule 1021A materials, and selected Rule 1021B materials as foreseen by the rules with very limited standard redactions. In the case of the document Your Honor mentioned, that was produced without redactions. That was produced on 11th of June, but only a very small number of redactions were lifted. Your Honor, we have met and conferred with our colleagues from the defense team on several occasions as part of our efforts to get them the materials they need and the materials they're entitled to. From our perspective, these meetings have been very productive. They've helped us understand which materials are particular priorities for our defense colleagues, and in response, we've tried to target our disclosure efforts to identify these most important documents while still proceeding in an organized and systematic manner. With respect to the 1021A materials that were disclosed on 11th of June 2021, they did in fact contain some 1021A materials, but it was only for materials that had previously been disclosed on 19th of May, and we lifted a very limited number of redactions in that subsequent disclosure. So our position is that the Rule 1021A disclosure was completed on the 19th of June. 19th of May, thank you. What was the next one? Yes, thank you. We did, in fact, complete the Rule 1021B disclosure on Friday, as anticipated. With respect to Your Honor's question about the 1023 material, we have begun the process of identifying that material. That process will be completed on 30th of July. Right? That process will be completed on the 30th of July. With respect to the Rule 107 materials, we are currently engaging with providers on a very limited number of documents. I believe that number is less than 20. We have not experienced any difficulties that we need to raise with the court at that time. At this time, it is one provider only that is involved. We'll update the court if there are any additional updates on that matter. Were there any other topics from that?
Just to clarify that the disclosure on Friday was partial, not complete.
Thank you. My colleague has clarified that the disclosure we completed on Friday was a second partial disclosure of 102.1b materials. We continue to move towards the 30th July deadline for the disclosure of all 102.1b materials. I hope that answers your questions, Your Honor. I've tried to hit them. Thank you, Your Honor.
Absolutely, thank you very much. So for 102.1a material, what you mentioned is that it's not new material, but it's just material for which a couple of redactions have been lifted, correct?
That's correct, Your Honor. A very small number of redactions.
Thank you, Mr. Prosecutor. Let me now turn to the defense. I note that the defense indicated in its written submissions that the protective measures requested by the SPO have an impact on the fairness of the proceedings and its ability to prepare for trial. However, this is not a matter that is meant to be discussed in detail at this conference, but I invite the defense to raise any such point in its response to the SPO's second request for protective measures. The defense also noted that the heavy redaction of material disclosed to date and the fact that the identity of a number of witnesses that will be called to testify has been withheld from the defense, preventing it from proper notice of the prosecution's case. I will now give the floor to the defense to discuss any issues or any difficulties with the ongoing disclosure process and the points I just mentioned. Mr. Gillissen, you have the floor.
Thank you, Your Honor. Well, I should start with our relation with the SPO, and particularly with the SPO team of Mrs. Giudice and Mr. O'Down, because I would like to underline the high quality level of professional relation between our team and the team of the SPO. So far, it's really a high quality of contacts, and I second them, really. The process of disclosure under Rule 102.1a took place and was conducted smoothly, really smoothly, and with a perfect goodwill. I want to focus on and to underline. Our colleague has confirmed to us that the disclosure under rules, this rule, has been completed. Additionally, our colleagues agreed to our request to provide us with some video recordings related to the accused himself. This kind of agreement has to be commended, in my opinion, because provides the possibility to everyone to work properly and avoid unnecessary litigation and delays. So, we have made some other requests to the SPO, and we are discussing with them regularly with the view of obtaining or prioritizing the disclosure of certain elements that we consider necessary for understanding of previously disclosed material. So we look forward to maintaining and continuing our good and constructive cooperation with the SPO. I think, Mr. President, Your Honor, I have nothing to add about the problem of the first problem you indicate. All is in the written material, so I think it's a good thing. I thank you for hearing.
Thank you very much, Mr. Gillissen. Mr. Prosecutor, do you want to add anything on the compliments addressed to you by the defense, which is not that often in this courtroom?
No, thank you, Your Honor. We're grateful for the good collaboration with our colleagues on the defense.
Thank you very much. Maybe just one question, Mr. Gillissen, on the point that I mentioned about the Rule 1021A last disclosure. Do you consider that you received the last disclosure on 19th of May, as mentioned by the prosecution, or on 11th of June, because this is when the last documents were disclosed with the least amount of redactions?
We received the latest documents on the 11th June. Thank you.
Thank you, Mr. Gillissen. This is noted. Mr. Prosecutor, do you want to add anything?
Your Honor, the redactions that we lifted were standard redactions, which are part of the agreed-upon redaction protocol in the case. So we don't think that affects the applicable deadlines in any way.
Thank you, Mr. Prosecutor. Unless the defense has anything to add? No, I don't think so. We'll move to the second item in our agenda, which is the status of the SPO's investigations. In its submissions, the SPO indicated that it is yet to conclude its remaining investigative steps. However, considering the limited nature of such steps, it does not envisage that these additional steps will impact their disclosure deadlines. Mr. Prosecutor, can you indicate when do you plan to complete the investigative steps you mentioned in your written submissions?
Your Honor, our current hope is that we'll complete the investigative steps before the end of the disclosure deadline on 30th July. If we're not able to do that, we'll promptly inform the court of that.
Thank you, Mr. Prosecutor. This is noted. I turn to the defense. Mr. Gillissen, do you want to add anything on this point?
No, thank you very much. Thank you very much, Your Honor. We took notice and there is no comment. Thank you.
Thank you. Let me now move to the SPO pretrial brief and related material. In its written submissions, the SPO indicated that in light of the disclosure calendar set out in the framework decision, which is scheduled to continue into October 2021, the SPO anticipates that it will be able to file its pretrial brief and related materials by Friday, 19 November 2021. Mr. Prosecutor, do you want to add anything to your written submissions on this point? And can you confirm that this date is indeed the date that could be ordered for you to file your pretrial brief?
Thank you, Your Honor. If it's acceptable to the court, we'll rest on our submissions.
Thank you, Mr. Prosecutor. Mr. Gillissen, on the this date for the SPO pretrial brief.
Thank you. We do not have something to add or to say. Thank you.
Thank you, Counsel. Having heard the parties, I will issue a first oral order on the submissions of the SPO pretrial brief. I hereby order the SPO to submit its pretrial brief within the meaning of Rule 95(4)(a) of the rules by Friday, 19 November 2021 at the latest. This concludes my first oral order. For the next point on the agenda, I would like to turn to the defense first. I note from the defense written submissions that it confirms its intention to carry out investigations for the purpose of the presentation of its case. Mr. Gillissen, based on the information given by the prosecutor in the course of the status conference, are you in a position to elaborate on the information provided in your written submissions on, first, the status of your investigations, second, any intention to give notice of an alibi or other grounds for excluding responsibility and any associated disclosure, and third, any intention to make requests concerning unique investigative opportunities? Mr. Gillissen.
Thank you, Johanna. I would like to explain myself. The next deadline for the SPO disclosure under Rule 102(1)(b) is 30 July 2021. We expect to receive important material which would allow us to have a better understanding of the evidences and material that will be used in the trial. So, we are waiting for, but I'm sure things will go as planned and without any problem. We expect to be in a better position to inform you, Your Honor, and provide reliable information about our progress and intention in the next statute conferences. So, Mr. President, as you know, the organization of an investigation on the grounds, it's a very high, difficult and delicate business. You can trust me, really very difficult business. We are able to say that we have identified a number of individuals capable of supporting us and assisting us on the ground for our investigation. We will apply every care, and I want to underline every care, in our selection process in terms of the person we cooperate with and the action to undertake. I'm sure you're able, Your Honor, to understand it's difficult to add something else at this stage. So, about defense of alibi or grounds for excluding responsibility, we are not now in a position to give any indication or clear indication. And this is the same for the unique investigating opportunity. I'm just able to talk about the chart under the Rule 109, but my friend of the prosecution team explained it. We confirm, Your Honor, that we receive a model of chart from the SPO colleagues. This document will serve as a basis for our discussion with the SPO. We will keep you informed about the mutual progress in the next TQ conferences. I have to talk about our request, but after, I suppose. Thank you very much.
Thank you very much, Mr. Gillissen. One point about the issues you just mentioned. If you want to raise any of these defense, whether it's ground excluding responsibility, or if you want to apply for a unique investigative opportunity, please do so at the earliest opportunity and not at the end of the pretrial proceedings when the case is ready to be sent to the trial panel. These issues might take some time, especially for unique investigative opportunities, and I would like to avoid unnecessary delay for the case. Mr. Prosecutor, do you want to add anything on this topic?
No, thank you, Your Honor. We have nothing to add at this time.
Thank you, Mr. Prosecutor. Next, I would like to ask the defense and the SPO to give their views on the procedural calendar for preliminary motions. At the outset, I take this opportunity to remind the defense that request for an extension of time limit whether it's for preliminary motions or any other filings actually, must be made in written filings, not by email. I note that the defense requests an extension of time so that the deadline for filing any preliminary motions be moved to the 11th of July 2021. I note that if we have a very strict understanding of the rules, that this would not even be a request to postpone the deadline if we consider that the last disclosure has been issued on 11th of June. But that said, I would like to ask the defense whether it requests to be authorized to file any preliminary motion at this date or any time later. I am minded to give each party the time they need to prepare, respond, and reply to the preliminary motion, as long as the calendar is reasonable and it does not delay the pretrial proceedings as a whole. So I invite the defense to indicate if they would like an extension until July 11th or beyond, for example, just before recess. Mr. Gillissen, on the calendar.
Thank you very much, Your Honor. We did decide to fill this request because we are working on a double basis of preliminary motions. We have the intention to file the preliminary motion, the first one, challenging the jurisdiction of the KSC under Rule 19.7.1, and another preliminary motion challenging the form of the indictment under Rule 97.2. So we introduce our request to Your Honor by email. I'm sorry for that. On 15th of June, and we have duplicated our submission in our filing of the 17th of June concerning the statute conferences. To summarize our position, Your Honor, we are seeking an additional time to file our preliminary motion until the 11th June 2001 for the following reasons.
Mr. Gillissen, I guess 11 July.
I say June?
Yes.
Oh, I'm sorry.
And you said 2001, I guess you mean 2021.
Yes, it's more than an error. Thank you. It is on the 25th of May 2001 that we receive a less redacted indictment which provides us and Mr. Shala, and I can say Mr. Shala was a strong expression, with a better understanding of the charges. Second, on the 11th June, upon our request, we received further disclosure under Rule 2002-1A from the SPO. We admit this new material is video version of previously disclosed transcript of interview of the accused, but it was really necessary to work properly with Mr. Shala. There are also a redacted version of previously disclosed material that was significantly redacted before. These elements were really necessary to help the defense, and also Mr. Shala, and I underline Mr. Shala, ascertain and verify certain informations. Third, we are operating, as Your Honor knows, under the basic level of budget and financing of the defense teams available under the KSC regime. Unfortunately for us, this budget level has been recently confirmed by the registry for the pre-trial phase, so we continue to do our best to carry out our mandate to defend Mr. Shala in this proceeding and to make it diligently and efficiently. We are operating on many fronts, both on the evidence, and on the law, but also in the setting up and management of the team in Den Haag, and of course for the investigation on the ground. It takes a lot of time, a lot of energy. It's a very delicate question sometimes we have to face. The defense of Mr. Shala submits that the preliminary motions are essential elements of the defense for Mr. Shala, but also important component of this case and his case. Mr. President, we need until 11 July 2021 to do this preliminary motion properly. It's not a lux, Your Honor. In the next weeks, everybody has a well-deserved recess and recover and regroup. Everybody, and it's a perfect situation, except us. We hope to benefit a part of this recess, of course, we have family too, but we are conscious and we know and we decide that we need to work during July and August, including we hope to go for the first time on the ground during this moment. We are accepting the disclosure on the Rule 102.1b on the 30 July, and early in the September, I think the 3rd September 2021, on the Rule 102.3. So we propose a date in September for the next ATU conference. But please, really, please take into account all the deadlines and elements we anticipate to deal with during this period. So in September, we also have to indicate the material we want to access from the SPO list. The deadline to do so is 17 September 2021. So September will be a little bit busy. Your Honor, thank you very much for hearing and your wise understanding of our situation. Thank you.
Thank you, Mr. Gillissen. At the outset, I want to mention that I want to give the defense all the time it's need to file and reply to the preliminary motions. As you say, it is a very important segment of the proceedings, and I intend to give both parties the time they need to prepare their filing as best as they can. I understand from your submissions that you would like to be able to file your preliminary motions on 11 July. I think, if I'm not wrong, that 11 July is actually, and I'm checking on my computer right now, is actually a Sunday. So can I take from your submissions that you would like to file your submissions on 12 July, which is a Monday, which is not a holiday?
Could be better. Thank you.
Thank you, Mr. Gillissen. And before I give the floor to the prosecution, I inform the parties that I do not intend to set any deadlines during recess apart from urgent matters and detention issues. This is practice across the board, all the cases. I think all the parties and participants needs some rest during the recess, so we will limit our work to urgent matters. So we will, all deadline that will end during recess will be postponed until after the recess. Mr. Prosecutor, so would the, first, what is your views on the date of the 11th of July for the defense to file its preliminary motion? Do you have any argument against? And here, let's not go back to the issue we discussed before. Just on this date, would your disclosure under 102.1a be or not finalized on the 19th of May or 11th of June? That's my first question. And my second question, how long do you need to file your response to the preliminary motions? So please let me know what would be a good date for you to issue your response. Mr. Prosecutor.
Thank you, Your Honor. As we've informed our colleagues on the defense side, we have no objection to their request for an extension. With respect to our response date, I think 2 weeks would probably be sufficient to respond to their motions.
So, would the deadline for the defense be on the 12th of July? This leads us to the 26th of July, which is in recess. Do you want me to put the end of recess for your deadline or middle of recess, so you have the full 2 weeks?
Your Honor, probably better to err on the side of safety and to seek to set the deadline at the end of recess, if that's acceptable to the court.
Thank you, Mr. Prosecutor. Let me now turn to the defense, because I'm also mindful of recess for the defense team. This is also why I think you are entitled to have real working days to prepare your reply. Would the deadline for the prosecutor to file its response be the end of recess, which would be Friday, August 13th? How long would you need to prepare your reply? Mr. Remy.
Thank you, Your Honor. Good morning to everyone. Regarding the timeline for a reply for the defense, we think that 2 full weeks would be sufficient for the defense to lodge their reply. So might need us to the 27th maybe of August then. Thank you, Your Honor.
So let me make a proposal to all parties and tell me what you think about it. Proposal to have the defense file its preliminary motions by 12 July, then the SPO response by 13th August, which is a Friday, and then the defense reply by Monday 30th of August. Would this calendar satisfy both parties? Turn to the defense first. Mr. Gillissen.
Yes, and I thank you. Thank you very much.
Mr. Prosecutor.
Yes, thank you, Your Honor.
Having heard the parties, I will issue a second oral order on the time limit for submission of preliminary motions. I hereby vary the timeline for submissions of any preliminary motions and order the defense for Mr. Shala to file its preliminary motions by no later than 12 July 2021, the SPO to respond by no later than Friday 13 August 2021, and the defense to reply by no later than Monday, August 30th, 2021. This concludes my second oral order. At this point, I would like to ask the parties whether they have any other issues they would like to raise. I note that the defense raised the issue of the conditions of detention in its written submissions. So I would like to hear the parties on any other issues, including this one. Mr. Prosecutor.
Your Honor, we have no other issues to raise at this time. Thank you.
Thank you, Mr. Prosecutor. I turn to the defense. Mr. Gillissen.
So thank you very much, Your Honor. We don't have anything to say for the condition of the detention. We have found some solutions. It will be nice, I think so. If some of the problem we'll have to raise, we make our best to try to manage with it, and I hope not to be obliged to come before Your Honor. Thank you.
Thank you, Mr. Gillissen. For detention matters, I always invite defense team to link with the registry first, because I think practically all the time the registrar has been able to provide practical and efficient solutions for the defense teams. Madam Registrar, do you want to add anything on this matter or on the evolution of the COVID regime?
Thank you, Your Honour. In relation to any matters raised by the defence regarding conditions of detention, I think we are satisfied that solutions have been found and any requests made by Mr Shala have been addressed by the Chief of Detention and the Principal Officer. In relation to the restrictions in place due to the pandemic, I am very glad to report that in consultation with the medical officer, we are working towards the lifting of some of those restrictions and have filed recently the update that it is our intention from the 15th of July to have in-person family visits in the facility, and also depending on developments with the Delta variant, and also the actual state of play with Defence Council and with their vaccinations. We also hope to very soon once again have in-person meetings in the same physical room with Council. But to note, family visits are fully facilitated on an ongoing basis by Zoom, and Council visits also in a room that provides the necessary protection for Council as well as the accused. But as indicated in the filing, thankfully, we see progress in the near future. Thank you, Your Honour.
Thank you, Madam Registrar. This is excellent news, and I thank you very much for all the efforts to facilitate the communication between accused and their counsel and accused with their families. Mr. Gillissen, I see that you ask for the floor.
Yes, Mr. President, I'm really sorry. I forgot to thank Mrs. Registrar for her help. It was very helpful from her. We have some solution because of her. Thank you.
Thank you, Mr. Gillissen. Delighted to hear that. I would like to ask the parties for their views on the next status conference. Mr. Gillissen, I think you indicated a preference for September. Mr. Prosecutor, do you have any preference for the date? And if I may, maybe just after you have filed the Rule 1023 notice would be a good date? Mr. Prosecutor.
Thank you, Your Honor. Yes, that works for us. We'll be available at the court's convenience.
Thank you, Mr. Prosecutor. Mr. Gillissen.
Yes, Mr. President, if it is possible, in the second part of September could be nice. I have to receive a medical intervention, a tiny one, but a real one, at the very beginning of September. So it could be better, excepting if you want to see me with some problems, medical problem or health. Thank you very much.
Thank you, Mr. Gillissen. Would it be possible the week of September 12th, or would this be too early? I say that because the courtroom might not always be available after mid-September, and I will try to would prefer to try to have the status conference before. So the week, it's actually the week of 13 September. Do you think it would be possible?
If is it possible to have 1 week more, you know, it will be better, I think so. Thank you.
Thank you, Mr. Gillissen. I will see what is possible for the calendar. Mr. Ayuni, you wanted to add something?
Yes. Sorry, Your Honor. Just to add that we have the deadline of 17th of September to select or indicate the evidentiary material we're interested in from the notice of the SPO. So from the 3rd to the 17th, we might be very busy with what we think and anticipate to be a few thousands of documents from which we would select. So obviously, that should be taken into account if possible. Thank you, Your Honor.
Thank you very much, Mr. Ayuni. I don't see any other parties or participant asking for the floor. You will receive a scheduling order in due course that will, as usual, include the agenda before the next status conference. This concludes today's public hearing. I thank the parties and the participants and the registrar for their attendance. And as usual, I thank the stenographer, interpreters, AV technicians, and security personnel for their assistance. The hearing is adjourned.
All rise.